Clearly was not happy about the fact that the 50 million Ghana cedis bail condition slapped on Chairman Wontumi is still hanging, even though they have consistently said that he cannot pay or he cannot afford. Somebody is screaming, Kilentia. Kilentia. Don't worry. Let's go to Parliament now. Alexander Kwamena Afenyo-Marking is minority leader. Yesterday, he led his team in his nice suit to sit on the floor on the street. But before that, listen to him.
Iyoko, without delay, must revoke and vary that onerous bail condition. The man is still in the hospital. You are demanding 50 million worth of property. Yesterday, when one surety got there, they now said that the person to go and do inspection has closed. It's not available. You go there at 10 o'clock, they say it's not available. Mr. Speaker, we should not do this to ourselves until Iyoko is able to do the right thing. We, the MPP side, however our numbers, will protest by absenting ourselves from proceedings of this house and join him. We are all going to sleep there with him, and we are not going to ask for any property. We don't have 50 million worth of properties. Where is he going to get it from? That go and bring landed documents.
Having regard to the constitutional principle, the supreme law of the land, above and beyond which no further law exists, what then is expected of Parliament? I believe this is a matter that can adequately be addressed by the judiciary. For me, if a decision of an institution can be challenged at the court, if a security agency pose a bail condition that you feel that the bail condition is harsh, I do not think Parliament will have the authority to call for a review of that particular decision.
Have they looked at the Constitution? They should vary the bail term. The man is unwell. He's in their custody. They know. So they should vary. Wontumi will not run anywhere. And I'm telling our friends in the NDC, 4 years will soon come. And if they think what they are doing is right, they should watch it. They should watch it. Treat others the way you expect them to do unto you.
Are you?
So if you keep Wontumi, is he using bail to punish him? We are here, we are protesting. We expect him to do the right thing. What has Wontumi done? Huh? Why are they?
Sunrise on 3 FM.
Have they looked at the
best in the morning?
Because they said the one we never have president in T. Ghana need you. Ghana for Musorio. Ghana for Musorio. And before you know Musorio. And before you know Musorio. I am Munti and I'm Mahama MC. This vice president da. Me Madam Board Suda. Me my DCO da. Me my minister da. I chairman in media. And I want to be campaigning mommy. I'm not me campaigning mommy party. And I'm here Juma 2013. We are about the boom Juma. Mubaye, my topping my Juma, my count to pa, me did here was one. Me, my count to club, me did you was no. So the Tiam and my school fees club higher thing. What I say, most of them won't start to my count to so, and Nasabi, me, sick a bain of the family. Minagana need you. Because they said the one we never have president in T. Minagana need you. Ghana for Musorio. Ghana for Musorio. And before you know Musorio. And before you know Musorio. I am Munti and I'm Mahama MC. This vice president da. Me Madam Board Suda. Me my DCO da. Me my minister da. I chairman in the media. And I want to be campaigning mommy. I'm not me campaigning mommy party. And I'm here Juma 2013. We are about the boom Juma. Mubaye, my topping my Juma, my count to pa, me did here was one. Me, my count to club, me did you was no. So the Tiam and my school fees club higher thing. What you say? Muslim de monsa to my account so and you know na sabe me sika bay na befa me ho.
Is to be listening to our Lady Chair on ensuring that you have the competencies to be in the place that you are put. And I was reminding myself of recent conversations when people would say to me, you have held up, you have done well in this onslaught. And I realized that what has held me up is the assurance of competence. Simply, no decision that I have made in my role as Chief Justice or in my capacity as President of a panel of the Supreme Court has come from anything but a knowledge of law. No matter how many noises are made, the law is the law. And the only answer one can give to all the hand-waving is the legal answer, unless we want something else. But I am quite sure that Ghana as a society is not looking for Chief Justices that bend and give them something other than law. And therefore, here I am. Everyone gets the law.
Ghana need you. Because they said the one we never president. Ghana need you. Ghana for Musorio. Ghana for Musorio. I be before you know Musorio. I be before you know Musorio. I am Munti and I'm Mahama MC. This vice president da. Me madam board so da. Me my DCO da. Me my minister da. I chairman na media. And I want me campaign in Mammy. I'm me campaign in Mammy party. And I'm here Juma 2013. We are about the boom Juma. Mubaye, my top in my Juma, my count to pa, me did you was one. Me, my count to club, me did you was one. So the Tia me must school fees and club higher thing. What I say, most of them won't start to my count to so, and you know, now me, sika bay, na befa me ho.
Free FM Sunrise. Free FM Sunrise.
We know that the Deputy Attorney General and Minister of Justice, Dr. Justice Edem Stremsai, has been speaking. Helen, what has our learned Deputy Attorney General been saying?
Certainly, he says suspect Bernard Intribosiako, a.k.a. Chairman Wontumi, is under investigation for various criminal offences, including fraud, causing financial loss to the state, and money laundering. The criminal investigation is running concurrently with asset recovery processes to prevent further dissipation of what law enforcement agencies strongly suspect to be proceeds of crime. The suspect is also under a second strand of investigation, which is part of a larger international organized crime scheme. The Economic and Organized Crime Office, EOCO, is working with international law enforcement partners on this second strand of investigations.
So this is what the Deputy Attorney General says. So it's not witch hunting, according to the Deputy Attorney General. It is just a matter of due process. Six, you want to help us with this conversation. We know now that Mr. Wontumi or Chairman Wontumi, Mr. Intribosiako, has been granted bail. He has to satisfy the conditions, and then based on that, he will be released. That's where we are now, is that also?
Yes, that's where we are.
So why is Yoko still holding on to him?
The latest information in fact, so as of last night, we knew that he had been unable to meet the conditions of bail that were set out. Let me take you a step back. That the whole grant of bail is what the lawyers will call a discretionary remedy.
Right.
That it is at the discretion of the court to grant you bail once you are arrested. The lawyers also, you know the celebrated case of Martin Pebu.
Right. Pebu 1 and 2.
Where it is said that bail should not be used as a punishment to continue to detain somebody. That bail, though, is at the discretion of the court, must not also be used as a tool of punishment.
Right.
And the popular saying that now everybody on the street knows. Every offense is bailable.
It's bailable, that's right.
So that probably set the tone, and some lawyers have argued that it didn't even have to take Martin Pebu for that realization to be made, because the law in itself had made provision and had made certain exemptions that it is only in the case of when you are charged with piracy, for instance,
right,
that you won't enjoy bail. The law itself had made those provisions before Martin Pebu went to court. Now, again, that it is at the discretion of the court, and that the conditions so set by the court must be reasonable. The conditions must be reasonable because the law does not want the arresting or detaining authority to set certain conditions that would make it impossible, practically impossible for you to be able to meet. So don't say that, okay, Abi, the law says you are entitled to bail.
Right.
You there will give you the bail. But the conditions will give you. You won't be able to meet the conditions.
It's almost as if we're not giving you.
We are not giving you the bail. And those arguments have been made. Those as a reporter at the courts, you have seen situations where people have been granted bail and they remain in police custody for hours on end, and sometimes days, because they were unable to meet the conditions of the bail.
Some big uncle who has a house that
would
could be used as surety is not ready to come. He's in the hinterland doing some business, so you say Chen Kakra.
Exactly.
Matthew.
So the conditions must be reasonable. Reasonable in the sense that it has to be within your capacity to meet those conditions. So you would hear terms like this amount with 2 sureties to be justified and all of those things. When they say 2 sureties, you are fine. It means that you can just call Abiam and say, Abiam, I beg you, Charlie, I get matter or can't stand surety for me, make I get bail. That is fine. You can almost get anybody.
But if Abiam too has a case and is suspected, and he gets there and they pick him up too.
But you get case, you won't go stand surety.
The Ghana with it.
Now, when you hear 2 sureties to be justified,
right,
it means that the law is looking at the standing of the persons that you are bringing in as sureties,
right,
or as guarantors. Let's use the word guarantor so that all of us will understand. You, the person standing as surety, you are guaranteeing to the court that any day, any time you want Helen Apia Ampofo in court, Helen will be there.
Right.
And I assure you that she will be there. If she is not able to come, find me, I will find Helen for you.
And if you don't find me,
you will be the one.
So the bail conditions set forth, that amount that has been mentioned, and you see, it is also not cash. That's the other thing that people need to know. They are not saying, in the case of Wontumi, bring 50 million Ghana cedis.
Right. But bring us something that is worth 50 million.
That amount.
Ghana cedis.
So that if you abscond, Helen, and Abiam is the one who's to as your guarantor, the property that Abiam has put forth would then be used.
Okay.
Do you get it?
Is that why the police will follow the individual who's standing as surety to their property to go and assess? So they know exactly where to find it.
You have to know where the property is, the worth of the property, be sure that the property is in your name. If it is not in your name, you can't go and use your father's house as this one in
surety.
Your name. It is not your property.
To build 6-2, how?
To build, yeah.
When your father doesn't know about it.
About it.
Then when it is time for the law enforcement agencies to come for that property, your father say for where?
For the where?
It's not.
Or you are in a rented apartment, then you are using it.
No.
No, it is not your property. It is not your property. So that is why the police will always follow you to the particular physical property to say that, to ensure that yes, the property is in existence, the documents are in your name, and you are actually a person who can stand the terms that you say you are guaranteeing. Okay.
Very good.
So the terms must be reasonable. That's where we were. In talking about the reasonableness of the terms too, there's another consideration that is made,
which is
that the amount in question, if it's a case of fraud, for instance,
and fraud has been mentioned by
fraud
the
has been mentioned in this
AG.
case, in the Wontumi case,
right.
Fraud has been mentioned. The AG, deputy AG mentioned fraud. If it's a case of fraud, question is how much is the amount involved?
Okay.
And that amount will be considered in setting the bail amount.
Okay, so it must be what? At par or higher?
Or within the region?
To be safe, let me say at par.
Because
let me not mislead.
Because if
but it cannot be below.
Okay, we get it.
It cannot be below.
Now, if the bail condition now is 50 million, right? It means that whatever is being demanded or is being investigated of Ms. Chairman Wontumi could be around 50 million, right? Or maybe a little less than 50 million. That's quite a huge amount of money.
Yes.
And the minority leader says, look, he cannot. So vary the bail conditions and let's see what we can do. Is he justified in that comment as well?
The minority leader is a seasoned lawyer.
Right.
And I'm sure that if he were the lawyer for Wontumi, he wouldn't have been using the floor of Parliament to make that argument. He would have been on the floor of the court making that argument, which is an obligation on the lawyers of Wontumi. That the detained or detainee, if the bail conditions are set for you and you are unable to meet those conditions, your lawyers can go back to the court and argue before the court that bail as is entitled has been granted, but the conditions are excessive, are unreasonable. There are specific words that I'm using. If you argue before the court that these conditions that have been set are unreasonable, and so you are praying the court to vary the terms as granted by the detaining authority, then the court will look into the reasonableness of the terms are set.
So that Bernard Ahiafo hasn't said anything wrong yesterday. He said on the floor of Parliament, he says Parliament cannot review Wontumi's bail terms.
No.
Minority go to court.
That is not a platform.
That is why I made the point that...
So he responded to the minority leader. He says, we can't do anything.
And mind you, Mr. Ahiafo is also a lawyer.
He's also a lawyer, yes. Right? So that's why, that's why I made the point that the minority leader is a seasoned lawyer, and if you were representing Wontumi as legal counsel, the floor of Parliament wouldn't have been his forum.
Yesterday, the minority leader also mentioned tit for tat, and he says that we should not create a vicious cycle. My good friend Edem sent me this. It says today, minority knows that bail conditions shouldn't be used as punishment. The God of Gregory Afoko is peace building. You know, Gregory Afoko was granted bail. right? And we kept him in there for how long?
How many years?
So many years, more than 5 years.
So he couldn't meet the bill conditions.
He couldn't meet the bill conditions.
Couldn't meet the conditions.
And for which reason he was
he
kept
remained
in there. Now, at the time when he remained in there, the institution that held him and granted him bail cannot be blamed for holding him.
No.
Even though his counsel had complained that the bail condition was too harsh, he was still kept in there. Even though he was on bail, but I mean, he couldn't meet it. So technically, even though he had not been jailed, right, beyond the period when he was incarcerated, he was still in there under the same conditions as though he were in jail because he couldn't meet the conditions.
Yes. So it also comes back to the point
can we then say that now Chairman Wontumi technically is not within the custody of Iyoko because Iyoko wants to keep him? He is there because he has not been able to satisfy the bail conditions.
That's a legal argument that can be made, and rightly so, because the detaining authority has met its burden. The burden of the authority is ensure that you do not keep this person beyond 48 hours without the lawful authorization of the court. So within the 48-hour period, Iyoko grants you bail and sets condition for the bail. And it's also important to explain that bail can either be conditional or unconditional. There are times that you can grant, they arrest you, Helen, and they say, okay, we are releasing you, you go. When we need you, we know where to find you. You are on TV every morning, you are on radio every morning, so we know where to find you. So that is what they call the recognizance bail. You are a big woman in the community. We know you. I mean, you have property that we can easily, you are very well invested in the country, so there's no way you can run away. Did she say amen?
So we have property, I'm just receiving it.
So you go home, go and sleep in your house. If we need you tomorrow, report at 9:30 a.m. If you don't come, we will come for you because we know where you are. We know who you are, and we know how much you are worth. Now, the other one is to bail with conditions.
Right.
And the conditions is where all of this drama then comes in. They will set you the court will set the conditions, say that you are to meet this, meet that, before you can be released on bail.
Right.
If you fail to meet those conditions, then it is no longer on the authority, the detaining authority. No.
Okay.
It is on you. You then have to, your lawyer then have to go back to court to make the argument that the conditions were harsh or they were excessive, unreasonable, and so you're asking the court to vary those conditions so that you can meet them.
But as it stands out, he's not been charged. These are investigations that are ongoing. Chairman Wontumi has not been charged as yet with the crime. Is that right?
I'm not too sure.
For the Iyoko one?
Yes.
No
charge as yet.
Let's go on to the phone line. Osman Al-Hassan is a private legal practitioner. He's joining us here also with Professor David Abdullahi. He is governance advisor at the Africa Parliamentary Network. Gentlemen, good morning. Thank you for your time.
Good morning. Good morning. And good morning to your listeners.
Counsel, let me begin this conversation with you. You had the minority leader yesterday making an appeal, if you will, in Parliament for Parliament to intervene for the bail conditions to be varied. And then also at the frontage of Iyoko, suggesting that the bail conditions were too harsh. Did he use the right platforms to make those appeals?
Definitely not, of course. I listened to your colleague in studio, and he was making very, very, very good advancements in this regard. But definitely that wasn't the right forum. Bail conditions, as he was explaining, bail conditions are terms that are attached to your liberty as an accused person, you see. And usually when we say bail is usually to ensure that an accused person has not absconded justice or will avail himself to stand trial. You see, there are so many instances, even within this jurisdiction, where people who are accused of one crime or another have left the country and never returned. We have a history of people who have been tried in absentia. Okay? So the law has made provision for these things so that the gravity of the offense or the gravity of the sentence upon conviction or the amount of money, quantum of loss that is involved in the offense will always dictate how strict the authority will be in allowing in allowing you to be at liberty or to be in custody. You see, they are not the determinants of the bail, but they are conditions of the bail. You know, so that if you run away, there is something to latch on to defray or to offset the value of what the offense you have committed, at least. Right. And you see, when he explained that when you sign a bond, a bail bond, it is not because they want you to satisfy the terms of the bail bond immediately. Those terms will be extracted after you have failed to avail yourself to stand trial. But to answer your question, you see, the minority is not doing all these things because they are fighting for a certain principle that is applicable to everyone. Because, you see, the minority leader was the majority leader when Fix Ghana, or what do they call them?
Yeah, Fix the Country.
Fix the Country guys were arrested, and we see how they were treated.
Right.
In fact, innocent people were added to that. He was the majority leader. He didn't raise this in Parliament. There were several other people who were arrested during that time in inordinate ways, and we didn't hear him. So definitely, this is being done not because of a principle, but because the person is a member of the MPP party, and that is worrying. Because if the membership of a political party is sufficient, that alone is sufficient for a whole minority leader in Parliament to stand up and fight against arrest. They are not concerned about the grounds for the arrest or the detention. They are just concerned that the person is detained. And detention is lawful. They can detain you upon arrest for 48 hours. Okay, and in this case, I understand he's been granted bail.
That's right.
He's just not being able to fulfill his bail conditions. So I don't know why anyone will cry foul to the extent of making a case in Parliament, and as a lawyer, he knows that Parliament cannot vary the bail terms of an accused person. You know, and the demonstration they did was not something that could vary it. You know, if it could, it would have. You see, but it is the offense, the nature of the offense, the gravity of the offense, and what the quantum of money that is involved in that offense. You will hear. Again.
If I hear you right, are you saying that the demonstration was a waste of time because the MPs knew what platform they could have used to vary or get what they wanted?
It is not just waste of time, it's waste of energy, it's waste of resources, because some media has to go and cover them. They have to do, it's just waste of resources, energy, and time, of course, because all that is resources. You see, if you go and demonstrate that someone's bail conditions be varied, by who? By the authority who tests them. Definitely, there's reasonable grounds based on which that authority set those bail conditions. The only way to vary it is either to convince the authority that those bail terms are not reasonable, or to go to a higher authority and seek a determination that the bail conditions were unreasonable. And that's the court. And it is surprising to me that all of a sudden, these guys have lost their way to court. They had been challenging people to go to court. And all of a sudden, they've lost their way to court. And they are besieging streets. You know, they are taking over streets, you know, because, you see, even that demonstration or whatever it was it in accordance with law, or because they are members of parliament? Because you need protection of the police in this regard, and you need to notify police, and the law is there regulating that. You just walk out of parliament and you go and besiege a constitutional, a state institution, and you say you want bail conditions varied. You know, they can't do it if they are not convinced that the grounds on which they have set those bail conditions are not reasonable. Or whatever the case, we will have what we are seeking to protect at the end of the day. That is the accused person availing himself for. And you see, national security and the security personnel, as in general, usually know something we don't know. And we don't know why they are detaining and why they are giving this bail condition, because perhaps they have some information that is likely to abscond justice. You see? So, if they want, the only way, just to answer your question, the only way to vary the terms is just to go to the court and let the court vary. But before they go there, before the case ends, perhaps, you see, it's needless.
I see.
It's needless. Let's just try and fulfill the bail condition. I'm not sure the amount mentioned is too big for such a person, because we have all had some public knowledge of something that he's not a man of straw, I should say.
Prof, let me bring you into the conversation. Yesterday, we saw the minority in Parliament walk out of Parliament after their attempt to get the bail conditions for Mr. Bernard Ntwi-Boesiako varied was shot down by the second deputy speaker in Parliament. Now, you tell me, parliamentary time was taken away from us because we saw our MP sitting on the floor and while business waited to be conducted. Are we doing this parliamentary thing right? You tell me.
No, I don't. My opinion, I'm laughing because I don't think they are doing the parliamentary thing right. But I think as a young democracy, I would still say they have the right to, walk out of parliament. For example, during the NDC era, you saw that when Atu Faustin, was being, they tried to jail him. The MPs walked out of parliament to support their candidate. But also the NDC during the e-levy, the effort to pass the e-levy, they also walked out of parliament. However, even though I have said that they have the right to walk out of parliament, they should understand that if they stay away for a certain period of time without getting permission from the speaker, they can be charged. So it is very, very important. Secondly, I think parliamentarians are there to make law and represent their people. And I think any cost-benefit analysis on the part of the minority would have told them that they don't have a supermajority like the NDC has in parliament. So if they don't want to avail themselves to make laws, the laws are going to be made on their behalf and their people. And they don't have a say because the NDC has a majority to be able to form a quorum and also to pass some laws. So I think, like my colleague was just speaking, I don't think they are asking for the varying of the 50 million is excessive, and I don't think it was the right forum. And I think the first deputy speaker, who's also a lawyer, told them that if you really want that to be valid, you are in the wrong place. Go and see the court. But I also question myself, where was his lawyer, Andy
Apiakubi? Right.
Yeah. If you are there, I mean, because Yoko and others allowed his lawyer to be there, why couldn't he have either asked them if there's a way to go about it, or how could he go about varying the
bill conditions?
Because it's too much. But why didn't he do that? So for me, it raises a question, and I agree with the previous speaker that, I mean, what in this day and age, I mean, what are you going to go and sit in front of a government agency and say, if you don't do it, you're not going to go home? I don't know whether the rain did some of them, but they won't sit there for the whole day. So my issue is we should take our democracy serious. I mean, the reason why that amount was actually one of the bail terms was that, like my colleague said, maybe they have some information we don't know. I also heard the Deputy Attorney General talking about the fact that some other things have come up that have to do probably with
international crime and all of that.
Yes, we didn't know that. Nobody knew that. We thought it was just, the fact that he was engaged in galamsey. So we should be very, very careful by politicizing everything. And, Johnny, I have talked on your show about the fact that our country, the politics is just it's bipartisan. It lacks thinking about whether this is right or not. So long as it's against my party, whether the person is wrong or not, we don't agree. But you did the same thing to other people when you were in power. So why is it that now you are a minority and you are fighting against the same things that you did to the others? It doesn't make sense. Not that I'm saying that an eye for an eye is correct, but I think we should be rational enough that when we do some of these things, we think about our actions carefully. And that is what happens, because in a democracy, when there is just an eye for an eye, sooner or later you begin to see that it could drag us into a civil war or something that can bring about instability in the country. And that's not what we want.
Counsel, I'll come back to you again. 50 million, the call is that it is too expensive. And just yesterday, you could also see that, for want of a better expression, the leadership of the demonstration, including parliamentarians, including party top executive, were not feeding their supporters the right kind of information as to why Mr. Bernard Ntwebuesiako was being held. Because if you listen to the narrative by the people, they seem to suggest that this is persecution. It is the president of the day who is asking for him to be picked up because power has changed hands and all of that. Are we helping ourselves in this regard if we do this?
You see, that's the, I should say, the hypocrisy about the whole thing. Or I should say double standard. Okay? So now, instead of communicating the reasons for the arrest and detention, you see, which of course, the Deputy Attorney General has just filled us in about, that the man has been facing an investigation in respect of fraud, financial loss to the state, and money laundering. Okay, we didn't know that. You see, so instead of communicating why the man was there, they were speculating motives. Okay, and what I find the double standard is that you are speculating a motive and imputing it on the authorities and basing your action, your demonstration on that speculative motive. But you think that the authorities cannot also speculate that the man will run away and detain you. Let's assume that even the authorities are speculating. They are thinking that, okay, now when they finish speculating, then they come to want us to believe that this is a man who has presented himself, he will not run away, and blah, 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 blah. So why are you speculating on one ground and want us to believe another speculating? So you have a right to speculate, but the authorities do not have a right to do so. And I believe that even the authorities are not speculating because they have access to security gadgets. They have access to security, to privileged information that is not available to the public. So I think they are not doing the public good if all they say. In fact, if you listen to the minority leader yesterday, sitting there, he mentioned two things. That harassment and persecution. What's the evidence for that? We only heard that the man was arrested and was detained and was granted bail before the expiration of the constitutional limited period. So, if there is harassment and persecution, what's the evidence of it? You see, all these things were speculation. And I want to believe that there was no persecution and there was no harassment whatsoever. And the institutions that were working on the Kuwazo or the previous XPP government are the same institutions that are working. And the modus operandi hasn't changed. It hasn't changed because we have seen what happened in the previous government. And that's why I said, you see, if I find someone fighting the principle and you are demonstrating against the principle across board, that is fine. But if you make it glaring to us that your fight is for partisan gains, or you are rather starting a fight you think, a war you think will extend to your very self. Because most of the people who were demonstrating to me are people who can also find themselves in the same situation because one way or the other, they were involved in some government businesses or transactions that are questionable. So it's like, if you don't fight this, you extend to me. So I will fight it the last drop of my blood. But is this the way to fight? So you see, when the person is acting on emotions, the law is in loss with him. Because lawyers were demonstrating and saying things they shouldn't be saying. Okay? You don't say that because someone is harassed, is persecuted, you have left your work in Parliament to go and sit on the floor. Is that the only person who has ever been arrested? John, didn't we see, even before today, people died in jail. Didn't we see that?
That's right.
Didn't Victor Solomon die in jail?
That's right.
Before he went to jail, was he not arrested, detained, and tried? What didn't Chetiskata fall sick in jail and was taken to the hospital?
Right. He was arrested in church, actually.
Exactly. So what has changed? Juan Pepra was arrested, detained, tried, and sent to jail.
Right.
So all this while, where were these people? You see, if they had risen at that time and then demonstrated and showed that this is. But do you think that if Ibrahim Mahama was not arrested and detained, the minority leader would be? No, I'm just asking you a rhetorical question. Don't answer.
I won't answer.
Yes, but the point is that you will see that they are coloring our legal and constitutional processes with partisan politics, which is not good. Because you yourself, you hear the minority leader say, he's not fighting against Wontumi standing charges of offenses that he has committed, but he's being persecuted and harassed. What? So where is the evidence? And if you think he's being persecuted and harassed, is the solution to go and sit there in the floor and abandon the most sacred work that your people have given to you in your constituency to go to Parliament? Because of one individual. And the only reason is that individual belongs to the MPP party. That's all. There's nothing national or public about it. So you have abandoned the elected public duty to go and sit on the floor and fold your legs like a malam, and then you are demonstrating and speaking things that we can't prove.
I'll come to you, Council, for the closing thoughts regarding what the next step should be. But Prof, stepping for me, this Parliament is crucial, particularly because President Mahama will not be president again. He needs this Parliament to be able to build and leave the legacy that he is hopeful of leaving behind after he's gone. Now, the NDC, or if you like, the majority, have an overwhelming majority. Should they ignore the minority, turn up in their numbers, and conduct business in the interest of this JM legacy? Or should they, in solidarity with them, go because they say tomorrow is pregnant?
No. I think the work of the country should move forward. If members of parliament in the opposition are not willing to play their part, I think the others are going to play their part. Not only about the president's legacy, but about the movement of our country out of this current stage we are in. Most of the countries we had independence with much earlier are way ahead. Look at where we are, way back, despite our wealth. So that is why I said there should have been rationality amongst the minority to realize that there's a supermajority in parliament and they can make laws without you. And I gave the E-Levy case as an example. So I think it's not just about the president's legacy, but it's about our parliament being matured enough to always be able to analyze and understand that some of these things that are done just because of this bipartisanship does not help us. Because at the end of the day, if it is anything at all, some of them are lawyers. They should understand that, at the end of the day, none of us, nobody is above the law. And if you break the law, wait till the law takes its course. So at the end of the day, I think it's not just about JM's legacy. It's about our country's development. It's about the maturity of our parliament and our parliamentarians to understand that you are there to make laws that will guide and help us grow the country. So in my case, if they are not coming, well, of course, their own standing orders, they can be hauled in. And if they are found that guilty by, they can be suspended or even sacked. So they should make that effort to agree and disagree with the majority in parliament on legal issues, on things that are going to help the country, not about politics or individual political members. That, to me, doesn't make any sense.
Professor David Abdullahi, governance expert with the Parliamentary Network Africa, we're grateful for your time this morning.
Thank you.
Great. Council, you have the closing thoughts. So what are the next steps? What do we do next? What should the minority be doing? What should Lawyer Pia Kubi be doing at this time in the interest of Chairman Wontumi?
Yes, of course. I think the minority are members of parliament, so they should go and focus on the work on parliament, because there are a lot of things to hold this government accountable for, because we need minority in government. We always need, as a democracy, we need minority in government. They kind of give the majority a check, though I believe that this is the majority who is most likely to do things right. We always need the minority to bring us the side that we would otherwise not see. And so they should rather focus on parliamentary business, because that is a public duty. What they are doing is not a public duty. They are defending a partisan political interest. You see, and it is not everyone. In fact, there are members of the MPP whose interest is that this gentleman should face trial. You see, so it is for me. They should go and focus and allow the lawyer of the accused person to deal with the legal issues, because he's the one who has been contracted to deal with the legal issues. And the forums, as a lawyer, he should know, because Andy Kubi, what's the name?
Apia
the
Kubi.
Lawyer of, yes, Andy Apia Kubi will not be advancing or advocating for bail terms to be varied in Parliament. He will not be doing so in the street. He knows where to go. And the earlier he goes there, the better, because time is not on his side.
Counsel, I thank you very much. That's lawyer Osman Alassan, private legal practitioner, joining us here on Sunrise on 3FM 92.7, your urban lifestyle radio station.